Hello there and welcome again to the Employment Law Show. We are back for another half-hour episode. Good to have you along. John Scholes here right beside me, right there. Lior Samfiru, employment lawyer at employmentlawyer.ca. Right off the top, we always tell you how to reach out to Lior. You should anytime you have workplace matters. Don't be Googling stuff. Always make the phone call, send the email to Lior and his team, 1-855-821-5900, help@employmentlawyer.ca. And the one and only website you should be going to, like I said, don't Google this stuff, it's pocketemploymentlawyer.ca. Details on that a little later on the show. We'll put it to the test, as a matter of fact. And as you know, we get the phone calls, we got emails, we got questions. It's always a busy half hour, and a main topic as well, how employers pressure you to quit. Honestly, this does happen. We'll break that down in the second segment of the show, as you know, Lior. But we always get things cooking with a week that was, or case of the day. What do you got going on, pal?
John, great to be here to talk about employment law, to try to help as many people as possible with this very, very important topic. Because we all have jobs, because we all have to work for a living, it's so vital that we know and understand our workplace rights. Those rights are there to protect us. You know, our legislature and our courts came up with these laws over many, many years, and they're there to protect you. So if you think you're facing a workplace problem, I can almost assure you that there's a law, there's a path that you can take to resolve that issue, to help you. You're not dealing with it alone. You're not the first one to deal with it. And on the show, we try to tell you what you can do if you've lost your job, if you've been wrongfully dismissed, if you've been constructively dismissed, if your human rights at work have been violated, if you're being mistreated or bullied, your job is being changed. I think you get the idea. This is the time and place where you can get some help and some answers and solve those workplace problems. I want you to be empowered. Knowledge is power, and this is the show where you get that knowledge. But of course, 30 minutes, it's all we have for you today. Beyond the 30 minutes, no worries. You can reach me by phone and email. My team and I are here to help. And we want to make sure that you get that support if you have an employment law issue. And I'll give you an example with the case of the day, a situation that I dealt with very recently. I spoke with a guy who had been working for the last 2 years in a private college as a director of one of the college's programs. So he was in charge of that program. He was in charge of making sure that all the instructors were doing their job to bring in students. He was in charge of marketing. It was a job and a half, as he put it. Except, guess what? He was treated and called an independent contractor. Again, even though he worked full-time and only for this college, he couldn't even work anywhere else. There's only so many hours in the day. They called him an independent contractor. And what he told me is that pretty much everyone else that worked at that college was called an independent contractor as well. Well, why did he call me? He called me because, unfortunately, the college wasn't doing great, and they recently told him that he's going to be let go. He's going to be losing his job. So here's the thing. This guy was not an independent contractor. He was an employee. He was someone that was misclassified as an independent contractor. In fact, if I was thinking of ways where he could be more of an employee, I don't know that I could come up with ways for him to be more of an employee. Again, he worked exclusively for the college full-time. He had a college phone number, an email address. He was an employee. And because he was misclassified and he's really an employee, now that he's let go, he's owed severance. For him, in a senior role, a director of a program, after 2 years, he's 59 years of age, he's owed right around 6 months of severance. 6 months. He would not have gotten that if he was not an employee, if he was a contractor. He's misclassified, probably all of his other colleagues are as well, but I wanted to remind all of you out there as well. If you have a job, you work for one company, you're very likely to be considered an employee of that company. Doesn't matter if you've incorporated, doesn't matter who pays your taxes or who remits taxes. The law makes it look like if you're act like an employee, you are an employee, which means you have the rights of an employee, including the right to get severance. So if you lose your job, do what he did, call me, and let's make sure you get what you're owed.
You know, this one's actually a little surprising, Lior. You know, this isn't Joe's Pizza down on the corner who wouldn't know better. I mean, this is a college. I mean, they should know the difference between an employee and a contractor. And I can almost guarantee he wrote some sort of contractor paperwork that would outline the fact that, hey, you are an independent contractor, so have at her, enjoy the job. It's kind of shocking. So what are the criteria? And is there any middle ground for somebody working in that type of job where maybe he does some work on the outside? You mentioned this gentleman doesn't. This is all he does for a living. But what happens if you got 2 or 3 of these going on?
So first of all, you're absolutely right. You would think that they would know better. And I see this sometimes with private colleges. I see it with private school as well. It's easier to call someone a contractor,
Right.
except it's not legal. So there's a middle category. So on the one hand, we have an employee. On the other hand, we have an independent contractor. There's a category in between, which is what we call a dependent contractor. So a dependent contractor is someone that is not an employee, but they spend most of their time with one company. So they're a dependent, they're financially dependent on one company. That means that if they lose their job, they're still going to be owed severance. So there's these three categories. If you're not sure which one is you, you're probably not an independent contractor. That's why you give me a call.
And again, as we mentioned before, pocketemploymentlawyer.ca has a section on contractor versus employee. You know, it's interesting. It doesn't make a difference, does it, if he and this college, this big college, signed an agreement saying, yeah, we're all good to go. I agreed to it, Lior. I like it. Not now, of course, because now it's a severance issue. But during his entire employment, what has he just said? Well, Lior, it's fine. We both agreed to it. I don't see the problem.
Yeah. And that's the first thing he said. Well, look at this contract that I signed. It says, yeah, we all agree I'm an independent contractor. Again, the law looks at substance over form. So the law looks to see what are you actually doing? How do you work? Not what you signed. Anyone can sign a piece of paper. You know, I have 150 people working for me at my law firm. If I have them all sign paper saying they're contractors, that doesn't make them contractors, right? That's how the law works. So because of that, what we care is how you do your job, where you do your job, who tells you what to do. Those are the things that we look at to decide if you're an employee or a contractor, not what piece of paper you may have signed.
You may be aware that Lior and I and other members of the staff, other lawyers, have been doing radio shows across the country for years now. We get a lot of great calls on the show. Lior, as you know, we play back 2 or 3 of them every week on this show. Want to get to our first one, so we'll listen to it and we'll comment on it. So first phone call of the show is right here. Listen up.
My son got fired. He had an accident driving a bus into the shop, and he clipped a piece of equipment that lifts buses up. A couple of days later, the manager said, you're suspended without pay while I do an investigation. Well, 3 days later, he fired him. Can he get severance?
I take it this accident was just an accident.
He just miscalculated coming in the bus.
And how long has he been there?
6 years.
How old is your son?
31.
There you go.
Yeah,
what do you think,
and listen, let's take this at face value. Let's assume that the driver really did make a mistake, and because of that mistake, there was an accident. Let's assume that to be correct. That's not the real issue. The real issue is that enough to fire him without severance? Generally speaking, when it comes to an accident, a mistake, it's not going to be enough as a single issue to be to relieve the company from having to pay severance. Making a mistake, causing an accident, or even costing the company money on its own is not going to be enough. Now, if this was a series of many incidents and he was warned and he was told you can't do this anymore, maybe at that point the company can let him go without severance. But if this is an isolated incident, it's not enough. And for you at home, one mistake is almost never going to be enough to deprive you of severance. So based on what we know, this guy's owed severance. He did make a mistake, but severance still has to be paid. So the last question we have to decide, of course, is how much severance does he get? For that, we're going to go to pocketemploymentlawyer.ca. We're going to click on the severance calculator. Let's do that right now and see what we get. So we know that this person has been working as a driver for about 6 years. He's 31 years of age. Because he made a mistake, companies let him go without severance. You see right there that he's owed as much as 6 months severance, between 4 and 6 months of severance. That's what he's owed. You at home, by the way, if you've lost your job for any reason, if you want to determine how much severance you're owed, the easiest, fastest way to do that, just go to pocketemploymentlawyer.ca. Click on the severance calculator, use it. It's free and anonymous, so check it out.
You know, a lot of our viewers, Lior, are going to be shocked saying, hey, that's almost, he's creeping up to almost a month per year. Shouldn't that be 4 to 6 weeks? Is that not a misprint on your calculator there on screen?
No, it's not a misprint. It's not a bug in the system. It's not we're not confused. No, the law provides for that type of severance. This idea of a week per year is false. It's fake. It's not the law. For most people, that's a lot more than that, especially for short service employees. So just because you work for a company for a short period of time doesn't mean you get a week or 2 week severance. That severance you're going to be owed is still going to be measured in months. So no, there's no bug in the system. Use the calculator, the severance calculator at pocketemploymentlawyer.ca.
You know, I did hear, Lior, before we move on to the second call, that he also slipped in there that he was suspended without pay. You're thinking, okay, what's the problem there? He's been a bad boy, so he's suspended. He's not working. Why would he get paid? Is that right?
Yeah, well, and that's a very good point. In most cases, your employer, we're talking, of course, non-union environments.
Right.
Your employer does not have a right to suspend you without pay. Even if you've made a mistake, even if it's a disciplinary thing, they don't have a right to do that. They could potentially suspend you with pay. In most cases, they don't have a right to suspend you without pay. That could be a constructive dismissal, depending on how long that suspension lasts. So making a mistake, being penalized, punished, or disciplined does not mean you can be suspended without pay.
Again, the radio shows, that's where the phone calls come for the most part. Employmentlawyer.ca to find a station near you that carries our either nightly or weekly programs. So tune into one of those. Phone call number 2, Lior, is coming up right now. Listen up.
About 10 years ago, our company asked us to sign contracts that we'd never signed at the start. They paid us the additional money to sign the contract, so it made it all legit. Now we're finding out that they're going to be wanting us to sign a secondary contract, a new contract, because they're finding out their contracts that they had us sign weren't worth the paper they were written on, and some people have fought it and have won.
How do we navigate that one? What do you think?
Well, he just answered his own question. Because, yes, the reason his employer wants him to sign a new contract is because they didn't do a good enough job drafting the previous contract. But that does not mean that the employee wants to sign it. That new contract is going to be better for the employer. And I can tell you exactly what it's going to do. It's going to limit future severance. So if he signs this new contract and down the road he's let go, the fact that he signed this new contract can cost him tens of thousands of dollars in severance, maybe even hundreds of thousands of dollars. So very bad idea. Anytime your employer comes to you and say, hey, employee, we just need you to sign a new employment contract, don't do it. It's a problem. It takes away rights that you would have and gives them to the employer. You can't be forced to sign this contract. You can't be punished. You can't be fired for cause. Don't do it. It's an invitation for problems and losses later on. So be smart about it.
Does it make a difference, Lior, in this scenario if he's already signed the first contract? You know, we often talk about if you've been put on a temporary layoff, you accept it. Now you've opened the door for having to do it again. Similar scenario, well, you already signed the first contract, so you can't not sign the second one, or that does not apply.
Does not apply at all. He does not have to sign this contract. He should not sign this contract. And again, anytime you're working, you're doing your job, everything's fine, and on a Friday, your employer comes to you and says, yeah, you know, Bob, I just need you to sign this new contract. We just need this to sign. But, you know, your salary is the same. Nothing's changing. Nonsense. If nothing was changing, they wouldn't want you to sign a new contract, right? Obviously, what's the point? Don't do it. It's a problem. Let me see it if you want me to give you actual feedback. But my advice is almost always going to be, do not sign it.
We will take a quick break, get to our third phone call on the other side and our main topic as well. So stay tuned for that. Lots more. The Employment Law Show is just ahead. Don't go anywhere. People think you should go to the government to get severance pay. Employmentlawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at employmentlawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. Employmentlawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at employmentlawyer.ca. Alrighty, we are back at it again. Welcome back to the Employment Law Show as we continue on. Reach out to Lior and his team anytime by phone call, by email, 1-855-821-5900, help at employmentlawyer.ca. Any other concerns, you can go to pocketemploymentlawyer.ca. Lior, as mentioned, got the main topic coming up here momentarily, but we have our third phone call to get through first, and we'll get to that right now. Listen up.
a letter yesterday from my manager saying that I was being placed on a temporary layoff. I've been at my job for almost 15 years, and I am in sales. I'm actually a 100% commissioned employee.
In the time that you've been with this company, I take it this is the first time you're being placed on a temporary layoff?
Correct.
Oh, they must have heard us in the previous segment, so there you go.
Yeah, and I remember this call from our radio show, John, and for sure, this is a classic situation of an employer doing something it's not allowed to do. In most cases, again, non-union environments, of course, your employer does not have a right to put you on a temporary layoff. It's a significant change in terms of employment. Just essentially, they're saying, we're going to stop paying you. That's what they're saying, right? If they said to you, we're just going to stop paying you, you would know that that's not legal. Well, it's the same thing. They're just calling it something else. A temporary layoff is not allowed in most cases. That means that if you're put on a temporary layoff, the choices that you have are as follows. You can accept it, of course, and wait at home and see what happens. Fine. That's option one. Option two, though, is you can consider that to be a termination. We call this constructive dismissal. You can consider this a constructive dismissal, not accept it, and leave with your full severance. They would have to pay you your full severance. Of course, if you go with the first option, option one, and you accept it, by doing that, you're giving the company the right to do it again. So once they call you back to work months later, if they lay you off again and again and again, you may not be able to do anything about it because you let it happen the first time. So probably for most people, the better option is to say no, constructive dismissal. If that's what you want to do, before you say anything else to your employer, I want you to call me.
And it is time to move on to the main topic for the show. As you know, Lior, this week it is how your employer pressures you to quit and what you need to know. First question, what does it mean when an employer, pressures you to quit? How does that work?
So, pressuring someone to quit is a huge problem because quitting, resigning is something that an employee should do on their own voluntarily. By definition, that's what a quit or a resignation is. An employer pressuring you to quit is the employer deciding for you that you should decide not to work there. So it's a huge, huge problem, and it's not something that the law wants to happen, and it's not something an employers should do. And oftentimes employers do that because they're hoping to take the easy path out, to have you just leave on your own without them having to make a decision. And that's not something that you should be doing for the reasons that we're going to be talking about. If you're going to leave, if you're going to resign, you should be making the decision on your own, free of pressure, free of any duress. Anything less than that, don't do it.
So how does this look when an employer pressures you to quit? I mean, all of a sudden your swipe card doesn't work, or someone stole your knife off his chair, it's gone missing. I mean, how do they go about doing that?
Well, there's many ways, but probably the most common way an employer would pressure an employee to quit is by telling them that something worse is going to happen if they don't. So if you don't quit, we're gonna fire you. If you don't quit, we're going to suspend you. So they're threatening them with something and saying, well, this bad thing's going to happen. You can get out of this by just quitting. Well, guess what? If the company wanted to let you go, they can, but they would have to pay severance, right? So this is just a pressure tactic. A company doesn't get to do bad things to you unless you quit. Now, listen, if you did something bad, if you stole, if you committed sexual assault, if you committed fraud, and you got caught, yeah, you may as well resign, right? Because you're not going to be owed anything. But generally speaking, if you didn't do those things and your employer is threatening you, don't fall for that threat. It's a pressure tactic. Be smart and don't quit unless it's voluntary.
So, Lior, is the severance piece the reason why they go down this road? Because you got to think, if they're forcing you to resign, there's going to be resistance, people are going to be upset, there's going to be bad blood in the workplace. It would be easier just to let somebody go, but is it this? Is that what that's the big draw to forcing someone to try to resign anyway?
It's all about the severance. Let's not be beating around the bush. Let's make no mistake about it. If your employer is wanting you to resign, it's because they want you to leave so they don't have to pay you severance, so that they can save a ton of money and not have to write that severance check. Because an employer knows, hey, if we let someone go, we got to pay severance. That severance can be as much as 2 years' pay, 24 months. Man, how do we avoid that? If the employee resigns, guess what? They've done it, so we don't have to pay severance. So let's just tell them they have to resign. Let's just push them, threaten them, convince them to resign. And if they do, we just saved a bunch of money. Well, if you're a generous person and you want to give that gift to your employer, fine, resign. Other than that, if you want to get what you're owed, please don't resign unless it's voluntary, unless you're doing it without pressure. You don't want to be in a situation where you're potentially giving up the severance that you're owed.
So if we have a viewer who's on the cusp and maybe thinking about doing this because of the pressure of work, and now they're watching this show, if they do quit because of the pressure, is that the same thing as being fired in the end, or no?
So if your employer is telling you, hey, you're not going to be working here anyway, but we'll give you a way to do that by resigning, that's a termination. If you're not resigning voluntarily, that's a termination. You're still going to be owed severance. The problem, though, is this. If you resign because of that threat, unless there's a way to prove that that's why you've resigned, your employer is going to say, oh, no, we never pressured. You did this voluntarily. And then how do you get severance? If we can prove that you only resigned because they threatened, they pressured, they yelled at you, they threatened you into doing it, you can still get severance. Sometimes it's difficult to prove that, which is why I say the best course of action, if your employer says, hey, you better resign or else, is to say, I'll take the or else. I'm not resigning. I'm going to continue working here unless you decide to let me go. And that's that. If you do that, the company lets you go, you're going to be owed severance. It's going to be much easier to get you that severance. So be smart. And please, as a general rule, don't resign because of pressure without talking to me first.
If it's kind of a preemptive thing, Lior, like your spidey sense is going off, you just got a feeling that it's coming down the pike. They haven't told you to resign yet, but you just feel it's building up, it's going that way. Do you have any recourse? What do you do if they're trying to push you out?
Well, some employers try to push you out with many different things by, giving you negative performance reviews, warnings. They may put you on a performance improvement plan. And the best thing you can do is to have your ducks in a row. If they are accusing you of doing something, have the information in place to show that that didn't happen. Or tell the company, hey, I don't agree with it. If you think that the company is building a case against you, build your own case in response. Have the proper information documented. If the company gives you a letter saying you did X and Y, we're very unhappy. If that's not the case, if you're not agreeing to it, if it's a lie, write back a very respectful email and say, hey, this didn't happen. Here's what actually did happen. You don't want to be silent in the face of an employer building a case against you, because that could be held against you. Be smart, respond to it. And if you're not sure how to do that, if you're not sure how to build your own case, that's why I'm here for. Just reach out to me.
All right, we'll take one more quick break, Lior. We got a couple questions on the other side, and then we always wrap up every week with the Employment Law Rapid Fire. Those are for you. That's coming up momentarily here on the Employment Law Show. Stay with us. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Employment Law Show continues. The website we're going to now for our next question, Lior, as you know, is terminationquestions.com. It's free and anonymous, so feel free to use that anytime. Here is the question. I am a 58-year-old employee with 27 years in service manufacturing. All the employees at the company received a notice of termination due to terrorists and resulting difficulties. I was offered a week per year of service and severance and told, due to the circumstances, this was the best I could hope for. Am I entitled to more?
So I'm sure we all have heard of many businesses and companies that are struggling right now for various reasons, including tariffs, but other reasons as well. And they may have legitimate business concerns and they may need to cut costs, again, legitimately. But the fact that a company is struggling and it has to cut costs, and it didn't do anything wrong, the fact that that's the case does not mean it gets to pay less severance to employees. The same amount of severance has to be paid whether the company is doing well or if the company is struggling. And this company, yes, let's assume they're actually struggling. They're still going to be owing their employees a lot more than a week per year of service, a lot more. Let's go to the severance calculator once more. You'll find that at pocketemploymentlawyer.ca. Let's plug in the information and see what the right severance amount is. So in a manufacturing role at the age of 58, after 27 years, company says a week per year, that's 27 weeks. Nonsense. That person is owed anywhere from 18 to 24 months, not weeks, months of severance. So just remember this. Just because a company is struggling does not mean they get a discount on your severance. You're still owed your full amount. Call me or go to pocketemploymentlawyer.ca.
All right, next question, Lior, comes from the live stream, which you can tune into the live stream with Lior and the other lawyers in the firm hosting this every week. You can do it on Facebook and YouTube at ST Lawyers is how you join in, at ST Lawyers. I'm on medical leave and made it clear I intend to return. When I tried to initiate a gradual return, my employer delayed things by requesting more medical information. Due to health issues, I missed some emails. The last one, warning of termination due to job abandonment, which I only saw after the deadline. Do I have any recourse?
Absolutely you do. First thing I would do here is write to the employer and say, hey, I missed these emails. I just got them. I'll respond to them right now as soon as I can, or I'll make an appointment to get the medical information. That's fine. If the company says too late, no. That could be a wrongful dismissal and a human rights violation. An employer can't just set deadlines, arbitrary deadlines for responses, and it has to be understanding, especially if someone is dealing with a medical condition. And if you're trying to come back from a medical leave, really all you need is a doctor's note clearing you to go back to work. It's as simple as that. That again, if the company is asking for unreasonable things, if they want to know your specific medical circumstances, the medication or the treatment you're taking, those things are offside. You don't have to respond to that. So if any problems you're facing with returning back to work, the law is quite on your side, and it starts to enforce it by giving me a call.
And we will get into our final piece here of the show. As you know, every week, Lior, this is Employment Law Rapid Fire. Let's get it done. Okay, number one, employment rights rapid fire. Can an employee be placed on probation as a disciplinary measure?
As a practical matter, the answer is no. You can't really be on probation once you're past the first 3 months. If an employer puts you on probation, it doesn't do anything. It doesn't give the company new rights. It doesn't take away rights from you. So if they say it, don't fight it. It doesn't really do anything. Do the job to your best of your ability. And if you lose your job, call me.
Next question. Can an employee be let go for reporting harassment?
Absolutely not. It's an easy one. No matter what happens with the investigation, what the results are, you can never, ever be punished for reporting harassment. You should always feel free to advocate for yourself in those circumstances.
Rapid fire question number 3, Lior. Can an employee refuse to work overtime?
Generally, the answer is yes, unless you sign an employment agreement that says that you're going to agree to work overtime whenever asked to do so. If you didn't sign something like that, you can refuse, and you really can't be punished or fired for cause for that refusal.
Our next question is this. Can an employee still receive severance if an independent contractor?
So we were talking about this at the top of the show. The answer is yes.
Yep.
The reason for that is most people that think they're independent contractors have in fact been misclassified, and they really are employees in the eyes of the law. If that's your case, even if you're, so to speak, an independent contractor, if you lose your job, you're going to be owed severance. That severance can be as much as 24 months. So, of course, if you think your employer is trying to deprive you of that severance, please get on the phone and call me.
Got through them all, and that is it for this week. Thanks, Lior, so much. I'll give you some contact information to go away with as well. The phone number to reach Lior and the team, 1-855-821-5900. It's help@employmentlawyer.ca, and then pocketemploymentlawyer.ca. That's where the severance calculator is the only website you should be going to. Thank you so much for joining us. We'll see you next time on the Employment Law Show.